Deputy Speaker, I move the amendment circulated in my name. Speaker, this amendment simply removes section 367A from the Administrative Review Tribunal Consequential and Transitional Provisions No. 1 Bill 2023. And the reason for this amendment is also simple, because section 367A goes against the very principles of natural justice. Indeed, as drafted, section 367A would replace section 423A of the Migration Act, thereby maintaining a process which has always been unfair to refugees and asylum seekers. In essence, the provision would require the newly formed Administrative Review Tribunal to draw an unfavourable inference as to the credibility of the claim or evidence provided by an applicant if such information was not raised in the primary decision, in circumstances where the tribunal is satisfied the applicant does not have a reasonable explanation for the delay. The provision only applies to applicants seeking a review of protection decisions, meaning it will create a disproportionate and unfair disadvantage to refugees and asylum seekers. Speaker, there are many reasons protection applicants might not include certain information within their original claims. For example, asylum seekers and refugees often face language barriers when completing applications, which is especially problematic when considering that applications must be completed in English. Moreover, with inadequate government funding for translation and interpreting services, as well as limited availability for funding for legal services in this area of law, it's unsurprising that some asylum seekers don't provide all relevant information in their original application. Hence, it might only be after an original application is refused that they seek legal advice and find that they should have included additional evidence. Yet, if this section is included in the bill, the tribunal may not be able to consider this additional information. Furthermore, Speaker, it is well established that people seeking asylum typically experience trauma both before and during their arrival in the country they are seeking protection from, and, as the Refugee Advice and Casework Service explains in its submission to the Standing Committee on Social Policy and Legal Affairs inquiry into this bill, studies show that trauma, and particularly the kind of trauma experienced by people seeking asylum, often leads to memory loss or gaps, loss of concentration, impairment in cognitive function and the deterioration of mental health. RACS goes on to note that for some people seeking asylum, the need to cope with past traumas may lead to avoidance, suppressing memories or disassociation when prompted to recount their experience of these traumatic events, which helps to explain why there may be a lack of detail, incoherence or gaps in an applicant's retelling of an event. Additionally, Speaker, some asylum seekers may not include vital information in their initial application because of stigma, shame or a fear of authorities. For example, people seeking asylum because of their diverse sexual orientation, gender identity, gender expression or sex characteristics may be hesitant to include such important information in their initial application for fear of retribution. Indeed, Speaker, some asylum seekers come from countries where they can be imprisoned or even executed simply for being gay. So this hesitance is not surprising. As you can see, Speaker, there are a myriad of reasons why applicants may not have included vital information in their initial application. And despite the fact they may have a strong case for review, the way that section 367A is drafted has the potential to deny them access to protection and ultimately justice. Indeed, under subsection 2, unless the tribunal is satisfied there is a reasonable explanation for the applicant's delay in providing the information or evidence, the tribunal is required to draw an unfavourable inference to the credibility of the claim. And here we come to the next problem, Speaker, because reasonable explanation is not defined in the legislation. So if an applicant were to rely on any of the examples I have spoken about, there is no guarantee that these valid explanations would be accepted by the tribunal. This is simply unconscionable and reflective of the way successive governments have continued to treat refugees and people seeking asylum appallingly in this country. Speaker, the removal of section 367A is supported by many leading organisations, including the United Nations High Commissioner for Refugees, the Law Council of Australia, the Asylum Seeker Resource Centre and the Refugee Advice and Casework Service. The experts in this area have made strong recommendations for the government to remove this provision from the legislation, and I echo these calls because every person, including those significantly vulnerable such as refugees and asylum seekers, should have a right to justice in this country. Thank you, Deputy Speaker.
I thank the member for Clark. The question is the amendment be agreed to, and I call the Attorney-General.
Thank you very much, Deputy Speaker. In response to the member for Clark's amendment, I can say directly that the government does not support this amendment, which would remove the new clause 367A from the Migration Act. The new section 367A replicates the effect of the existing section 423A of the Migration Act. It requires the tribunal to draw an adverse credibility inference if a protection visa review applicant raises a new claim in the tribunal without a reasonable explanation as to why the claim was not raised before the primary decision maker. Now, just to repeat that again, it's important that it be understood that it doesn't prevent a protection visa review applicant from raising a new claim. What it does is to require the tribunal to draw an adverse credibility inference if that new claim is raised without a reasonable explanation as to why it wasn't raised before the primary decision maker. The context for this is that it's a relatively unusual thing for a new claim to be raised in this kind of proceeding. And bear in mind, importantly, applicants are able to put forward an explanation as to why a claim hadn't been raised earlier or why the evidence wasn't presented earlier, and the tribunal may choose to accept that explanation and not make the adverse inference. The purpose of provisions like this is to contribute to the integrity of the onshore protection status determination process. Protection visa applicants are required at the time that they apply for a visa to make specific claims about why Australia's protection obligations are satisfied in their case. And what this section does is to set a clear expectation that protection applicants raise all claims and present all available evidence at the earliest possible stage. And that's to ensure that the decision made by the primary decision maker is as accurate as possible. Of course, there are going to be circumstances in which a late raised claim is explicable or late raised evidence is explicable. There'll be explanations such as I couldn't find a witness, or I couldn't find a document, or I wasn't able to get the document. But that allowance is made in this provision. Retaining section 367A reduces opportunities for exploitation of the migration system. It supports expedient resolution of reviews of decision, and it does so in a way that preserves rights and recognises the degree of difficulty that very often applicants are faced with in getting their material together.
Thank the Attorney-General. The question is that the amendment be agreed to. I call the member for Clark.
In which case, through you, Deputy Speaker, to the Attorney-General, in which case then it all seems to hinge on what the tribunal decides is a reasonable explanation. And if I could just quickly whiz through a few examples, historic examples, and put the question at the end of these examples to the Attorney-General, would any of these do or not actually fall within the criteria for a reasonable explanation? For example, Mindy fled Nigeria having experienced serious gender-based violence from her family and fearing harm as a member of the LGBTIQA+ community. She was afraid to disclose her sexuality to the department because of stigma and a fear that her family or others in Nigeria might find out. Only after obtaining legal assistance was she able to articulate her claim and the reasons for delay in raising it, and ultimately she was recognised as a refugee. Another example is Mariama, who fled Sierra Leone having experienced female genital mutilation. She didn't raise it at the primary stage because she did not know it was relevant to her case because of how prevalent and normalised the practice is in Sierra Leone. Had she not had a lawyer, the presumption in the clause or the section could not have been exercised against her with what is a clear claim not considered. and her status as a refugee not being recognised. Or Atiba is a divorced woman from Ethiopia. She arrived in Australia having experienced physical and sexual violence from her former husband and persecution for her political opinion. Due to trauma and cultural taboo, she was not able to disclose the violence she had experienced until she had established a relationship of trust with a lawyer, which took months, Deputy Speaker. Without the lawyer, she would not likely have been able to raise the claims or to articulate the reasons she could not raise them earlier. Working through it with a lawyer, the presumption was able to be rebutted eventually. Or Litiana, who fled Fiji having experienced severe gender-based violence. She lodged an application raising these claims that was rendered invalid. Her second application, made with the assistance of a support person, did not include these claims due to the support person's negligence. After she was denied an interview at the primary stage, the tribunal raised the presumption against her and required submissions post-hearing using significant resources. I can say in this case a decision is pending. And Elnaz experienced physical and sexual family violence, including threats to kill and violence against her children, from her husband in both Iran and Australia over a period of years. She couldn't previously raise it because her application was joined with her husband. Further, she was afraid her family in Australia would learn what happened to her, and she feared her community's judgment of her if she disclosed the violence in her relationship. But with the assistance of a lawyer, Elnaz was able to rebut the presumption, leading to her recognition as a refugee. And finally, Deputy Speaker, Mubashir, these are obviously not their real names, of course, fled Pakistan fearing harm from the Taliban. He did not disclose at the primary stage that he had been targeted by military intelligence, as he feared that information would be shared with authorities and he feared severe consequences. So, in other words, Deputy Speaker, there are any number of applicants for protection who, for very good, very legitimate reasons, were not able to or did not think to or could not provide a full and detailed explanation of their circumstances. Surely in all of those cases the presumption should not have applied, and they should have been allowed to add additional information subsequently after, for example, they'd gained the trust of a lawyer or they were made aware of the scope of our laws and in what circumstances protection might be applied. So I am concerned, Deputy Speaker, that the section remains and that if it is going to remain, that it remains ill-defined in what circumstances the tribunal will be able to accept additional information. Thank you, Deputy Speaker.
I thank the member for Clark. The question is the amendment be agreed to, and I call the Attorney-General.
Thank you, Deputy Speaker. Just very briefly, the examples that were given just then by the member for Clark, with the greatest of respect to him, simply prove that there is a discretion currently, there has been a discretion, and that late-raised material is capable of being accepted. Late-raised material is capable of being accepted without the tribunal choosing to draw an unfavourable inference to the credibility of the claim in those matters. And I'm indebted in a way to the member for Clark for bringing forward those examples, because what we have here with the proposed new clause 367A from the Migration Act would replicate the effect of the existing section 423 A of the Migration Act, that being the provision under which all of the decisions that the member for Clark referred to, all of the examples that the member for Clark referred to were made. No one doubts the degree of difficulty, no one doubts the degree of pain and suffering that's been experienced by very many applicants for protection status in Australia, or the cultural barriers that exist that might indeed provide a reason why certain evidence wasn't brought forward at the earliest possible stage. No one doubts that the difficulty of obtaining appropriate legal advice sometimes means that unrepresented applicants at an earlier stage don't put their cases as well as they might, and that with the assistance of a lawyer they are enabled to put their cases better. But the tribunal, the current tribunal, the Administrative Appeals Tribunal, applying the current 423A of the Migration Act, has proved itself able in the past to see those difficulties, to make appropriate decisions which recognise that there were reasons why late raised material hadn't been raised earlier. And I certainly haven't heard in the examples put forward by the member for Clark with respect a reason for not continuing with the new proposed section 367A of the Migration Act, which, as I've said, preserves an appropriate discretion in the tribunal to receive late raised evidence.
Thank the Attorney-General. The question is the amendment be agreed to, and I call the member for Clark.
Thank you, Deputy Speaker, and through you I thank the Attorney-General for that explanation. Of course, this all seems to hinge on what is the definition of reasonable explanation. I think we could bring some clarity to this matter right now, Deputy Speaker, if the Attorney-General could perhaps read into the record his understanding of, or the government's understanding of, quote, reasonable explanation, unquote.
Thank the member for Clark. The question is the amendment be agreed to, and I call the Attorney-General.
I do thank the member for Clark for his suggestion, but I won't be doing that. I'm not seeking to fetter the future Administrative Review Tribunal with whatever thoughts I might have on the infinite variety of circumstances that can occur in protection applications and review of protection decisions. It's simply not possible to do so. That's why we use in legislation phrases like reasonable explanation. That's why we preserve discretions in administrative decision makers so that they can tailor their decisions to the particular circumstances that arise in the particular case. And there's always a degree of difficulty in either a minister or me in debate seeking to set out an exhaustive list of what I think might constitute a reasonable explanation, let alone attempting to do so in the legislation itself. There's got to be some scope for discretion. There's got to be some scope for administrative decision makers to match their decision making to the particular circumstances and the infinite variety of human life that come before them.
Yeah. Thank the Attorney-General. The question is the amendment be agreed to, and I call the member for Clark.
And finally and briefly, Deputy Speaker, I will take this opportunity to acknowledge the many people right around the country who do come to the assistance of asylum seekers to allow them to work their way through the processes that we're discussing and in the case studies I've given. And I would particularly like to single out my friends at the Asylum Seeker Resource Centre who, along with countless lawyers and other people around the country, have worked tirelessly to take a hold of an asylum seeker and to understand their circumstances and to help them make that application, in particular when the application is complex and there is a need ultimately to provide that additional information and to achieve the protection they seek. Thanks, Deputy Speaker.